let's talk about the rights of the accused during trial. So that's Rule 115. Okay, Section 1. Right of the accused at the trial. In a criminal prosecution, the accused shall be entitled to the following rights. 1. To be presumed innocent until the contrary is proved beyond reasonable doubt. So this is a constitutional presumption. So when there is a clash between the presumption of innocence and the presumption of public officials has perform their duty with regularity, the presumption of innocence prevails. So this puts the burden to the prosecution to prove the conviction beyond reasonable doubt. So in other words, the onus probandi is on the prosecution. So they must prove the guilt of the accused kasi he is presumed innocent until proven guilty. Yan. So second, to be informed of the nature and the cause of accusations against him. So when the evidence presented by the prosecution is capable of two interpretations, one consistent with the guilt of the accused and the other consistent with the innocence, we must tilt the scales to the innocence of the accused and he shall be acquitted. So ito ang tinatawag nating equipoise rule or the equiponderant doctrine. So kunyari yan, pantay yung evidence ng guilt and innocence. We must tilt this scales to the innocence of the accused and he must be acquitted. So we have to remember, if the glove does not fit, acquit. Okay. So also, how do we obtain this, to inform the accused of the nature and cause of the accusations against him? So dapat yung complaint or information must be sufficient, inform, and also it must be in the language or dialect known to the accused. Okay. Third right is the right to be the right to be present and to defend himself. The right to be present and defend in person and by counsel at every stage of the proceedings from arraignment to promulgation of judgment. From arraignment to promulgation of the judgment. So that is his right. However, he may waive his presence at the trial pursuant to stipulations set forth in his bill unless his presence is specifically ordered by the court for purposes of identification. The absence of the accused without justifiable cause at the trial which he had noticed shall be considered a waiver of his right to be present thereat, and when the accused under custody escapes, he shall be deemed to have waived his right to be present on all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears that the court that he can properly protect his right without the assistance of a counsel. Ayan. Fourth, meron pa pala dito yung to be present from the arraignment to the promulgation of judgment. So, pwede niya i-waive yung right niya sa to be present. To be present but may kapalit syempre, Kung kunyari, the accused waive his right to be present at the time of the promulgation of judgment, pwede nga, 'di ba? Ano naman ang gagawin ng court kapag ganon? So, the court will record the judgment in the criminal docket and will furnish the accused with a copy of the judgment through his counsel or at his last known address. But paano kung winave niya itong right na to? What will happen? He will lose all the remedies against the judgment. So, hindi ka na pwedeng motion for reconsideration, motion for new trial, or mag-appeal. Yan. So, you will lose all the remedies against the judgment. Yan. Ito naman, fourth, to testify as a witness in his own behalf but subject to cross-examination on matters covered by direct examination. His silence will not in any manner prejudice him. So, right to testify as a witness on his own behalf No? So although he cannot be compelled to testify, but if he wants to, no, if wants to testify on his own behalf, he can only be cross-examined as to matters taken up in the direct examination. Kasi sa witness, he can be examined um, sa regular witness kasi he can be examined even beyond those of those taken up during the direct examination. Ayan. So, pwede rin naman yung witness, parang sa accused din that he can only be um, examined on the scope of the direct examination if, yun nga, one, parang si accused, he testifies on as his own witness, or two, when the witness is hostile or an adverse party witness. The fifth right is to be exempt from being compelled to be a witness against himself. So, the right against self-incrimination is different from this right na, no? Kasi the right against self-incrimination may be invoked by any witness, but the right not to be compelled to be a witness against himself can only be invoked by the accused himself. So, this is different from again, right against self-incrimination. Kasi itong self-incrimination, itong right against self-incrimination, pwedeng i-invoke to ng any witness. Yan. So, dito sa Rule 115, itong right na to be exempt from being compelled to be a witness against himself is only available to the accused. Okay, the sixth right is to confront and cross-examine the witnesses against him at the trial. Either party may utilize as part of its evidence the testimony of a witness who is deceased, out of, or cannot with due diligence be found in the Philippines, unavailable or otherwise unable to testify, given in another case or proceeding, judicial or administrative, involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him. And to have a compulsory process issued to secure the attendance of the witness and the production of other evidence in his behalf. Of course, he also have the right to have a speedy, impartial, and public trial, and of course, to appeal in all cases allowed in the manner prescribed by law. So that is only the scope, no, of Rule 115.